Good afternoon, ladies and gentlemen, and welcome to today's webinar brought to you by myself, Nicholas Kisson. I'm a Senior Legal Advisor at LEASE, as well as a qualifying solicitor. I've been qualified for many, many years. Now, we have muted everyone's phone, but feel free to send in questions. You can type in questions in the chat box on the right-hand side of your screen, and I will propose to take any questions at the end of the webinar, which is scheduled to last about an hour. Now, on this particular slide in front of us, we've got a disclaimer, which I shall read to you. Whilst we make reasonable efforts to ensure our content is accurate and up-to-date, information and guidance in this webinar does not and is not intended to amount to legal advice in any particular case. No responsibility for any consequence of relying upon the webinar material or presentations of the webinar is assumed by LEASE or any of our advisors. The law, as stated during this webinar, is up to date as at today's date, 3rd of November 2016. And that's our topic today. It's Lease Extensions Part 2. It's a follow-on from a webinar I did almost a month ago, which took us up to the drafting of the Section 42 initial notice. Now, we're going to cover, following the drafting of the initial notice and it being signed off by whoever has the authority in your office to do so, that it's considered to be valid and in proper form, and also that if necessary, you've got your client to sign it, although you, as leasehold, although you can, of course, now have a power to sign it on their behalf with their authority. So the next step is properly serving it. Well, who gets the initial notice? Upon whom is the Section 42 notice served? Well, for valid service, proper notice has to be given to the following: the competent landlord. Now, you'll recall that the competent landlord may well be the immediate landlord, or if it's a tiered structure, it's anybody who has the power and has the length of lease or length remaining on the lease such that they can grant an extra 90 years on top of what's remaining on the lease beneath them. So that's the competent landlord, usually the freeholder, in a tiered freeholder head landlord under lease structure. So Section 42 notice is served on the competent landlord. Also, if there's any third party to the lease, if it's a tripartite lease, say with a management company, that's not got a head lease as such, that's not got a proprietary interest, it's a sort of floating management company, and it may comprise the leaseholders or might be controlled by the competent landlord or others. If it's a tripartite landlord and it's the management company, then also has to be served on them. And if there's a guarantor for the leaseholder, then has to be served on them. I have to say I don't see that many residential leases with guarantors. It tends to be commercial leases, unless I suppose it might be a shell company owning, say, a valuable flat in central London, and the freeholder insists on getting a guarantor, a guarantee of some sort, or surety from a third party. It might be a director of the shell company. Otherwise, one doesn't see guarantors that much in residential leases. But if there is one, they have to be served with a Section 42 notice. Now, the notice is not served until the third parties has been served. It's not been validly served. Who else has to be served? Well, copies of the initial notice must be given, that's copies, to everyone that the flat owner, the leaseholder, knows or believes to be the competent landlord or one of the other landlords. So if it's joint freeholders, you can serve one of them and a copy on the other freeholder. Or if it's a head lease that's not a competent landlord, there's superior landlord, the freeholder, say, at the top, then a copy will be given to that head leaseholder, the intermediate leaseholder. Now, each recipient of the initial notice or a copy of it must give a copy to anyone they know or believe to be the competent landlord or one of the other landlords who is not stated in the initial notice or known by the recipient of the initial or copy notice to have received a copy. And why do I spell that out? Well, there are serious consequences for failing to give notice to all the landlords who are expected to get the notice. And those consequences are this. If the competent landlord or any of the other landlords does not receive a copy before the time specified in the notice, the Section 42 notice, for serving a counter notice, and they have replied to a Section 41 notice served by the leaseholder or their representatives seeking information about that person's interest in the flat, the notice of claim will cease to have effect at the end of the period for serving a counter notice. Now, where that situation doesn't apply, but any person fails without reasonable cause to comply with the obligation to pass on notices or is guilty of unreasonable delay, then they in turn are liable for any loss occasioned or suffered by the leaseholder, the competent landlord, or any other landlord. Now, in that particular situation, the Section 42 notice is not invalid. But if the failure resulted in the competent landlord being unable to serve a counter notice in time, the loss could well be considerable if the landlord is unable to challenge the terms proposed by the tenant for a new lease. We'll come on to later what happens if a counter notice is not served in time by the competent landlord. Now, we said who is served. We now have to say where to serve. Well, if the landlord is, the competent landlord is an individual, serve at their residential address, the place where they're living, or if they're carrying on business as well, as an alternative, a place where they're carrying on business, where they're trading. If it's a company, a landlord, a company limited by guarantee or maybe limited by share capital, can serve at their registered office or alternatively a place where they're trading. But it's important to ensure that they do get in. Where to serve? In addition, you can serve at an immediate landlord's address given under a notice served under Section 48 of the Landlord and Tenant Act 1987. Section 48 states that a leaseholder should be given an address for service of notices, including notices in proceedings, and if they're not given that notice, then monies are not payable under the lease, service charges, ground rents, admin charges, insurance, until such a notice is given. But that address given is also good enough, sufficient enough to be an address for service of the Section 42 notice. If the landlord's outside England and Wales, in addition to giving their address, they've also got to give an address in England and Wales at which notices can be served. Section 47 of the Landlord and Tenant Act 1987 is another way of serving notices, another address. Section 47 of the Landlord and Tenant Act 1987 states that all demands for ground rent, service charges, etc., should be have the address of the landlord. And the address of the landlord should be the place where the landlord can be found or is trading or carrying on business. Now, the sanction there is that any part of the demand that features service charges, those service charges are not payable until there's been compliance with Section 47. What I'd add here is if you've got a Section 48 address, an address for service of notices, that trumps the Section 47 address. So if your client asks you to serve the notice, then it's a good idea to find out from your client if they've had an address for service of notices on the landlord, including noticing proceedings which comply with Section 48, because it's sufficient to serve at that address. How to serve? Well, there's no rule that says how to be served. What it says in the legislation at Section 99 of the 93 Act is it must be in writing, the notice. Well, that goes without saying, but also it may be served by post. So it's not obligatory to serve by post. There isn't a deemed service process as there is for enfranchisement of houses notices under the 67 Act. Now, how to serve it? Well, if you're serving in person, it's a good idea is to consider serving in person. Maybe getting a process server to do it, or sign an affidavit or a witness statement as to where, when, how it was served, and maybe the reaction of the recipient of the notice. When should you serve in person? Well, I think it's fair to say now and again you're going to come across competent landlords who may well be evasive. If you anticipate they may deny they received the notice if it's sent through the post, even if you do everything properly, good idea to serve it in person. If it's coming up to 80 years left on the lease, such that it's soon going to dip into marriage value territory, then it's a good idea to serve it in person. And it's a good idea indeed, as I said earlier, just to get an inquiry agent to do it, who can do a sworn statement or affidavit. Now, how to serve, as I said, it may be served by post under Section 99 of the 93 Act. There's registered, recorded, specials guaranteed the next day. Registered and recorded, of course, have their risks because they could well come back through the dead letter service weeks later. I think it's better to send it by ordinary post, although the ideal really is personal service, if that's logistically possible. What I wouldn't recommend is by fax. Some people still use fax. I can remember when they came in 30 years or so, it was a marvellous thing. Only crucial documents were sent by fax then, but then later on it was abused, so just about every single letter and document went by fax. Don't think many people use fax machines now. Please let me know if you still do. The faxes tend to be through the word processor. I don't recommend by fax, and there is some case law at county court level that says that by fax is not valid. It's not recommended anyway. Another way of serving, which I wouldn't recommend, is by email. It could go into junk email at the other end. The question is it valid service? Well, I haven't put it on the slide, but there was a case called Gray, G-R-A-Y, against Tayyib, T-A-Y-E-B, and others. It was a judgment of His Honour Judge Coltart, C-O-L-T-A-R-T, in Brighton County Court, handed down on the 18th of May last year. It was a collective enfranchisement claim about Section 13 notices. And what's interesting is that Kay came to the view that it was service of the initial notice by email is permissible. It's county court, it's at persuasive authority, but it's not a high-level high court or court of appeal or Supreme Court. Maybe the case issue will be tested later on. But what's interesting is that in February this year, on the 16th of February this year, there was a case about counter notices on lease extensions. Cowthorpe, C-O-W-T-H-O-R-P-E Road, 1-1 A Freehold Limited, against Wahadali, W-A-H-E-D-A-L-L-Y. And that was a judgment of His Honour Judge Dite, D-I-G-H-T, at Central London County Court. Judge Dite is quite distinguished in the field of landlord, tenant and leasehold matters. And they came to the converse view. It's a county court judgment, as with Brighton County Court, with the Gray and Tabb. But they said for the counter notice, the Section 45 counter notice, by email is not permissible. So we've got two conflicting decisions there. I think that we wait for it to be tested, the whole issue, at a higher level. But I don't recommend serving by email. Post, yeah. And if possible, best of all, service by post. Sorry, service in person. Now, part of the cockpit drill, once you've served the initial notice, do this straight away. You enter the initial notice at the register, the land register. You enter it against the freehold title, and if there are any head leases, intermediate landlords, against their title as well. What's the consequence of failing to register? Well, basically the consequence is that the initial notice is deemed void against the buyer of the freehold title or of the intermediate lease, as the case may be. It still might be right of first refusal, kicks in, but the initial notice will be deemed void. That could have serious consequences because you may well have just served on the cusp of the 80-year period. And serving another notice might bring you into marriage value territory. Now, as I said, don't forget to register the initial notice. And remember, there's a distinction between unregistered land and registered land. Still a fair bit of unregistered land. It wasn't until late 1990 that the whole rolling scheme for dispositions in respect of land became compulsorily registerable at the land registry. They were done in various stages. So there's still a fair number where the freehold title, any intermediate title, or indeed the lease of the flat itself, if it was granted many years ago, may still be unregistered land. What do you do if it's unregistered land? Well, then one looks at the Land Charges Act 1972, and it's registered at the Land Charges Registry, the initial notice, the Section 42 notice, as a Class C4, that's brackets Roman numeral 4 brackets, land charge. So that's at the Land Charges Registry. So do make sure that's done if it's unregistered land. Otherwise, the notice will be deemed void against the buyer of the freehold title or of the intermediate leasehold, as the case may be. Again, now, when it comes to registered land, most of the land now, I think, is registered in England and Wales. One falls back on the last major legislation involving land registration. It's the Land Registration Act 2002. It used to be cautions, for those who us old types who predate 2002 in terms of conveyancing practice. But now it's a species called a unilateral notice. It's form UN1. And there's a fee to pay. Do check what the fee is. Make sure it's the proper one that you pay. Guidance on the submission of the form UN1 unilateral notice can be found in Land Registry Practice Guide 27. You can find them online. Lots of useful practice guides issued by the Land Registry, and it's 27 that deals with leasehold reform legislation. That part of the practice guide that addresses the registration of unilateral notices in this context is paragraph 5.4.1. I cannot stress too highly whether it's unregistered land or whether it's registered land. Immediately after serving the notice, register it in the appropriate fashion against the freehold title or, where applicable, against the head lease interest or interests if there is more than one. Now, what's the effect of serving the initial notice once it's been properly served? Well, I've put up there three serious consequences, both on the landlord and the leaseholder. Well, for the leaseholder, no further notice can be given whilst during the currency of the initial notice. So whilst that initial notice is in force, and until such time as it ceases to have effect, either because it's void or because one completes the new lease, or say if it's deemed withdrawn, in which case you've got to wait 12 months anyway, as you'll find out later, as I explain. But during the currency of initial notice, whilst it remains in force, no further notice may be given by the leaseholder. It also restricts the landlord's ability to forfeit to end the lease. So if the landlord takes steps to forfeit the lease, and the legislation doesn't make it clear what that means, but I take it to mean issuing and serving possession proceedings in the county court, the landlord cannot do so without the leave of the court. So if a Section 42 notice has been served, a landlord cannot, in my view, issue possession proceedings, forfeiture proceedings, usually in the county court, unless they've had specific permission and leave of the county court to do so. And finally, on the leaseholder's side, once they've served the Section 42 notice, they are exposed to paying some of the landlord's professional fees. Not all, some of them. And that consequence from Section 60 of the Leasehold Reform, Housing and Urban Development Act 1993. I'm going to dwell a little bit more on costs later on. That's costs under Section 60. Of course, if a deal is done, then the landlord is likely to insist on their costs, perhaps on an indemnity basis. But Section 60 is not a complete indemnity for the landlord's costs, as will become apparent when I dwell upon Section 60 costs later on. Another effect of serving initial notice is that if you're acting for the leaseholder, the professional acting for the leaseholder, you should prime them for certain events that usually follow on, as night follows day, from service of the Section 42 notice. First is deduction of title, and I'll come on to that shortly. Next, there is digging into their pockets to pay what might well be a substantial deposit. I'll come on to that shortly. And finally, there is giving access to the landlord to in the flat, for the flat, in respect of the flat, for the purposes of valuing the interest in the flat. I'm going to say a little bit about selling the flat, but I'm going to also return to this theme of selling the flat later on in this webinar. Now, the initial notice can be assigned. It can be transferred to the buyer when the flat is sold at the same time or by means of a deed of transfer. Now, when is it useful to do that, to essentially buy an initial notice that's been served? Well, it's useful to have the initial notice served by the seller and assigned to the buyer where it's on the cusp of 80 years, and really where the buyer doesn't really want to wait 2 years from the purchase, which otherwise they'd have to wait before they could get a statutory lease extension, and they may not be able to get a voluntary lease extension during the first 2 years, might not be able to get a satisfactory deal. And it also might be that it's insisted upon by the buyer's lender that this process is followed before they'll advance money on mortgage security, particularly where the residue of the lease is short. As I explained in the previous webinar, lenders differ in the number of years they expect to see on a lease. But it may well be that the residue of the lease is in an area where lenders get cold feet, and they may insist either upon the whole lease being extended before they'll advance mortgage monies, or at least the process started of a statutory lease extension, such as, in this instance, the initial notice being served by the vendor or the vendor's solicitors and assigned over to the buyer so that they can complete the lease extension process, notwithstanding the fact that otherwise they haven't been the owners for 2 years. So I'm going to give you a basic run through on that slide of the process. The initial notice is served and a deed of assignment drafted and executed, perhaps using a decent precedent from a textbook. But it's worth, since it's the buyer who is going to suffer adversely if the whole process goes pear-shaped, it's worth considering that the buyer's solicitor drafts the initial notice and arranges it to be signed by the vendor's solicitor, and then the buyer's solicitor serves the signed notice on behalf of the vendor, perhaps, and then the buyer's solicitor also drafts the deed of assignment. Now, the important thing is if the process isn't done right, such that there isn't a proper assignment of the Section 42 notice, then there's a deemed withdrawal. And deemed withdrawal means that for a statutory lease extension, to serve another Section 42 notice, one has to wait another 12 months from the time it went pear-shaped, and also pay the freeholder's abortive Section 60 costs. Now, post-notice procedure, we've drafted and served the Section 42 notice. It lands on the landlord's doormat, or their appointed representative's doormat. What happens next? Well, we said get ready for investigating title to the leaseholder, and this is what happens. Within 21 days of the initial notice being given to them, the competent landlord can give to the leaseholder, perhaps via their appointed representatives, formal notice to deduce title, which and the leaseholder must comply within 21 days of the landlord's notice. What I would add is this: it differs from collective enfranchisement, where there's a similar formal deduction of title process with 21 days twice. Where it differs with collective enfranchisement, if the leaseholder doesn't comply within 21 days of the landlord's notice, there's a deemed withdrawal, and they've got to wait 12 months and pay the landlord's abortive professional fees. That's on a collective enfranchisement. There isn't that sanction and consequence with a deduction of title notice for lease extensions if the leaseholder doesn't comply within 21 days. But it should still be treated seriously. How is title deduced? If it's land registry, produce the most recent office copy entries from the land registry. You can get them online now for £3 or thereabouts, but do produce those. And what they should do is they should show 2 years ownership, as well as signifying that the leaseholder is the registered proprietor of the flat. There may be more complex documentation where it's unregistered title, examined abstracts, whatever. What if the leaseholder doesn't comply within 21 days of the landlord's notice? Well, we know it's not a deemed withdrawal like it is with collective enfranchisement, but the weapon available to the landlord is to serve a 14-day default notice, and if there's still no compliance, to seek an order of compliance, perhaps an injunction, in the county court, and if that order may well be backed up by a penal notice. So, although there's not a deemed withdrawal, one might still end up with county court costs if one is on the losing end of the county court proceedings, and indeed a penal notice attached to the order. We also said earlier that the leaseholder should get ready for payment of the deposit. What's the deposit? Well, that stems from the 1993 regulation, Schedule 2, Paragraph 2.1. The competent landlord may give to the leaseholder formal notice requiring payment of a deposit on account of the eventual premium price for the lease extension. They can do that as soon as the initial notice is served upon the competent landlord, and they can also, if they don't do it then, they can serve the formal notice for a deposit whilst the Section 42 notice continues in force. But I suspect, well, the landlord will probably serve it as soon as possible. What is the amount of the deposit? Well, it's greater of £250 and 10% of the amount proposed in the initial notice, and that's of all sums proposed, set out, including those payable to the the head landlord. That could be a sizable sum if it's prime central London and there's not a great deal of residue left on the lease. But so for that reason, the leaseholder should be advised well in advance, well before the Section 42 notice is served, that they may have to pay quite a substantial sum as a deposit. What's the process? Well, payment after being demanded should be made within 14 days, 2 weeks of the notice, to the solicitor or licensed conveyancer. Will hold it as stakeholder. That's different from holding it as agent. Agent, they can send it to their client straight away, the freeholder. The stakeholder, it's laid down in the legislation, they hold it to the account of both sides. And there's same methods of enforcement as for deduction of title. It's not a deemed withdrawal if deposit is not paid within 14 days. However, sorry, my voice is going. I've got some water with me. One can service a 14-day notice and then seek a county court order for deduction of title, and if granted, it might be backed up by a penal notice. As soon as the initial notice is given, there is an entitlement to inspect the flat, and that stems from Section 44 of the 93 Act. And that entitlement is given to the competent landlord, any other landlord. It might be an intermediate landlord. Usually the competent landlord's acting for both of them, but it might be the intermediate landlord, and any person authorised to act on their behalf, tend to be the valuer. And that says for the purposes of the statutory valuation. So primarily, really, for a figure that they can put in a counter notice. But that's an entitlement to access the flat purely for a statutory valuation. If it goes beyond that, then it's arguable that it's a trespass. When's it exercisable? Well, it's exercisable at any reasonable time on giving not less than 3 days' notice to the leaseholder. Now, it could be exercised on more than one occasion, unless there are some legitimate reasons why, then it may be difficult to get back the valuer's fees later on from the leaseholder. And the same methods of enforcement lie as for deduction of title and payment of the deposit, namely a 14 days default notice followed by an application to the county court for an order that, if granted, may be endorsed with a penal notice. We now come on to the landlord's counter notice, and that's in Section 45 of the Act. It has to be given by the date in the initial notice. And if you listen to the Part 1 webinar, it's not less than 2 months, the date from the date the initial notice is given. So it's got to be given within that time, and it's given by the competent landlord on behalf of all the other landlords, and the counter notice must specify any other landlords, like intermediate landlords, on whose behalf they are acting. Now, there are serious consequences for not serving the counter notice in time or at all, namely that the flat owner can apply to the county court for what's colloquially called a vesting order, namely an order that the lease is granted on the terms set out in the Section 42 notice, including the price, even if the landlord doesn't like them. Now, what are the contents, the basic contents of the landlord's counter notice as required by Section 45? Well, I've put them on the slide there. Basically, there has to be a statement either in the positive or the negative. Now, if it's in the positive, it will state that the landlord admits the leaseholder's right to a new lease, their entitlement to a new lease, on the date that they serve the initial notice. Or, conversely, it could be a negative counter notice, whereby the landlord states that on the date of service of the initial notice, they don't admit the leaseholder had a right to do so. Now, if they serve a negative notice, they've got to specify reasons why they dispute that right. And where it's relevant, it comes up now and again. There's not been a huge amount of case law on it, apart from Major States and Curtis in the highest court in the land. But where relevant, to state the landlord intends to apply for an order that they intend to redevelop the property. That really crops up where there's 5 years left to go on the lease, and the landlord can make out the case. Now, the counter notice will be invalid if it fails to comply with the contents requirements in the previous slide, which means that the leaseholder can, if they're in a position to do so, seek a vesting order in the county court. The counter notice should also specify an address in England and Wales, not Scotland and Northern Ireland or anywhere else overseas, at which notice may be given to the landlord. Usually that address will be the address of the landlord's solicitors. There's no saving for inaccuracy, unlike Section 42, as I covered in the first webinar. So the landlord or their professional representatives have got to get it right first time. Now, if it's a positive counter notice, they've got to go on to state which proposals in the initial Section 42 notice are accepted and which are not. And in respect of those that are not accepted, the landlord must specify a counter proposal. Usually it's the counter offer, an alternative price, which they might well go by a recommendation of their valuer, who perhaps has exercised rights under Section 44 to go into the flat. If there's an amount attributable to a head landlord in the initial notice, then the counter notice should address that as well. And whilst it's not obligatory to do so, it might be good practice to attach a draft lease, particularly if alternative terms are being proposed. And I'll come on to alternative terms later. Now, in respect of a positive counter notice by the landlord, where any disputes haven't been resolved over the price and or other terms of the lease, they go to the appropriate tribunal. In England, it's the first tier tribunal, brackets, property chamber, brackets, and has been since the 1st of July 2013. And in Wales, it's still the leasehold valuation tribunal, being the body that predated the first tier tribunal, property chamber in England. Now, either landlord or the leaseholder can apply. The landlord can apply if they want their money early. The leaseholder can apply because they want to get a move on, but there's also a sanction on the leaseholder if they don't apply in time. Now, the time to apply is 2 months after the counter notice and within 6 months of the counter notice. So there's a 2 months window from the counter notice being served to serve the to really negotiate, and then the deal isn't done on all terms, isn't settled on all terms. There's a further 6 months. There's a further 4 months to apply to the tribunal. So it's 6 months from the date of the counter notice to apply to the tribunal, but you can't apply earlier than 2 months from the date of the counter notice. Now, if the application isn't got in time to the tribunal, there's a deemed withdrawal, with the consequence being that another Section 42 notice can't be served for 12 months, and the landlord's abortive Section 60 costs have to be paid. If the landlord serves a negative counter notice, basically saying that they dispute entitlement to a new lease under the 93 Act, then an application is made by the landlord, not the leaseholders, to the county court for a declaration that the leaseholder had no right to a lease extension on the date the initial notice was given. And the landlord's got 2 months from the date of the counter notice to make that application to the county court if they're minded to do so. If they don't, then it's treated as if no counter notice has been given, and a vesting order can be applied for by the leaseholder. Now, the possible court orders on an application to the county court where a negative counter notice has been served are either a declaration in the landlord's favour that the initial notice ceases to have effect, or the landlord loses, their application is dismissed, and the court directs that the landlord serves a further counter notice within a certain time. As I indicated earlier, if the landlord fails to serve a counter notice, they lose, in time or at all, they lose the right to dispute the proposals in the Section 42 notice. An application can be made by the leaseholder to the county court. There's a 6 month deadline from the date of the counter notice to make that application to the county court. If they don't make that application in time, there's a deemed withdrawal. There's a lot of tight deadlines in this legislation. So diarising effectively and properly is important. There's no discretion on a vesting order application. If a proper notice properly served can be proved to the satisfaction of the county court, and it can also be served that a proper counter notice has not been served in time or at all, then the vesting order has to be granted by the county court, entitling the leaseholder to buy the lease extension under the 93 Act on the terms set out in the initial notice. So a reminder, which forum? If there's no admission, a negative counter notice, it's a county court with the application being made by the landlord. If the landlord opposes the 93 Act lease extension claim on the grounds of redevelopment, it's the county court, the landlord makes the application. And if there's admission, a positive counter notice, but proposals are disputed, then any issues that remain outstanding is down to the appropriate tribunal, LVT in Wales, First Tier Tribunal in England, to determine the outstanding issues, and the application can be made either by the landlord or the leaseholder. So summarised there, it's First Tier Tribunal Property Chamber in England, and it's still the old Leasehold Valuation Tribunal in Wales. And there's appeal forums beyond, whether it's England or Wales, to the Upper Tribunal Lands Chamber with leave of either the appropriate tribunal, or if that isn't granted, with leave of the Upper Tribunal, and then appealing beyond that. If there's any merits, an ability to finance it to the Court of Appeal and to the Supreme Court. So a reminder of the process. Section 42 initial notice drafted, it's served. Landlords, assuming they serve a counter notice, will assume it's a positive one. Alternative terms proposed, including price, by the landlord. Now, if those disputed terms are not resolved, then an application is made to the tribunal for the leaseholder not less than 2 months from the counter notice and not more than 6 months from the counter notice, otherwise a deemed withdrawal. Now, on to a crucial subject, terms of the new lease. Now, the new lease under the 93 Act will be on the same terms as the existing lease broadly. That's set out on section 57 of the Act. The only way it's going to differ, apart from what I tell you soon, is that the term of the new lease is going to be fixed. It's going to be the residue of the existing lease plus 90 years, and the rent under the new lease being fixed at 0 peppercorn, but otherwise on the same terms as the existing lease. There's little scope for departure unless one can argue for that scope for departure from the existing terms of the current lease, and that's provided for in other parts of section 57. First, there can be a change to the lease under section 57 brackets 1 brackets, where those changes are needed, are permitted or required to address the omission from the new lease of property included in the existing lease but not comprised in the flat. Also, where there have been alterations to the flat since the existing lease granted. So it might well be that what was a 1-bed flat and shown on the plan as such is now a 2-bed, or there might be an extension or something. But, you know, the plan or the description of the demise differs from what's happened since, and the new lease, the extended lease under the 93 Act, can be changed to show those. Also, if the existing lease derives from separate leases, it might be 2 separate flats, 2 separate leases knocked into one. Otherwise, the other method of really for the leaseholder to get changes to the lease are this: to exclude or modify an existing term, but not to introduce a new term. So it's just to exclude or to amend or modify an existing term. That's section 57 bracket 6 brackets of the 93 Act. There are 2 grounds for seeking an exclusion or modification, and those grounds are this: where it's necessary to remedy a defect in the existing lease. And that necessity to remedy a defect in the existing lease is construed narrowly. And now, Waite against Morris, 1994 case, and it was one of the first cases on the 93 Act, lease extension, the tribunal. That case said that a term requested by the leaseholder requiring the landlord to give the leaseholder's mortgagee 21 days notice of forfeiture proceedings, that was refused because it was not deemed to be necessary. It is regarded as convenient, but it was not deemed to be necessary. Now, a case of more recent vintage at the Upper Tribunal Lands Chamber was Birchall against Raj Properties Limited. I'll tell you the details. It was a 99-year lease of a flat granted in 1988, and that year's important. And that 1988 lease contained a use clause restricting the flat's use to use as, and note these words, as a private dwelling for the lessee and his family and for no other purpose. But it didn't contain any restriction on subletting. Leaseholder applied for a 93 Act lease extension. Freeholder wanted this provision carried over into the new lease, but the leaseholder sought the deletion of the words for the lessee and his family. The LVT in England, as it then was, decided that the contentious words should remain. The leaseholder presented 3 arguments in the alternative. 1, the use clause, properly construed, didn't restrict the use of the flat to use by the leaseholder personally. Alternatively, 2, its ambiguity was a defect which could and should be amended under the 93 Act, section 57 6A, by omitting it, Well, that if the wording did in effect prohibit subletting, the tribunal should exercise its power also under section 57.6 and remove the contentious words on the basis, as I'll mention in a second, of changes occurring since the lease was granted. Namely, the reduced security of tenure provided to short-term tenants under the assured short-hold tenancies provided for by the Housing Act 1988. So this lease granted in 88 predated the Housing Act 1988. And also the alleged practice on the part of the landlord in waiving the covenant in other leases in exchange for payment. Now, at the Upper Tribunal Lands Chamber, Deputy Master Martin Roger QC rejected the leaseholder's argument that the words for the lessee and his family had a completely different, substantially different meaning from the more commonly encountered one in the lease by the lessee as his family, as, if let, the dwelling, the flat, would still be for the benefit of the lessee, who would draw the rent for it. The Deputy President was left in no doubt the clause required personal occupation by the flat owner, the leaseholder. The Deputy President also rejected the argument the wording should be amended in the new lease, and that there were cases as well at the Upper Tribunal where it was accepted that there might be a genuine advantage in having a block of flats occupied by owner-occupiers rather than tenants as buy-to-let leaseholders. So to justify a change of the terms of the lease would require evidence of the alleged change of circumstances. This hadn't been evidenced before the LVT, and the appeal to the Upper Tribunal was dismissed. It's worth reading that case. I think it's the last case really that's dealt with this issue. But also, if you're looking at the Council of Mortgage Lenders Handbook, first came in 2002, so it was about 9 years after the 93 Act, and it's worth making sure that the existing lease is CML Handbook compliant. And if it isn't, and if the landlord refuses changes, then endeavouring to argue at the tribunal that those changes are needed to make them compliant with the CML handbook, and relying on section 57 brackets 6 brackets. The other ground, which I alluded to in Birchall against Raj, where it's necessary to remedy a defect in the the other ground where one can argue for it to be excluded or modified is where it's unreasonable in the circumstances to include without modification a term in question in view of changes since the date the existing lease was granted, affecting the suitability of provisions of the lease on the relevant date. So things like legislative changes perhaps, or changes in conveyancing practice, and that was alluded to in the Birchall and Raj case. Possibly the leading case on Section 57 is Gordon against Church Commissioners for England, heard in the Lands Tribunal about 10 years ago, the Lands Tribunal being the predecessor of the Upper Tribunal Lands Chamber. That case reiterated that the starting point was the terms of the existing lease, but Section 57 brackets 1 brackets gave a wider power to allow changes where it applies than Section 57 brackets 6 brackets. Now, Gordon against Church Commissioners was a case about the leaseholder attempting to introduce a new covenant obliging the landlord to enforce covenants against other leaseholders in the estate. They were ultimately unsuccessful in asking for this. Essentially, the Lands Tribunal came to view, as I indicated earlier, that Section 57.6 is about excluding or modifying. It doesn't allow new provisions, such as the landlord was to argue for, to be introduced into the extended lease. Now, even if it could, one could only argue on the two grounds, defect or change in circumstances. And a defect must be judged objectively and amount to a defect from the perspective of both the landlord and the tenant. There's also scope, as one can see in the slide, for a landlord to argue for service charge clauses to be inserted in the lease if they have various obligations, etc., that entail them dipping into their pockets but not being able to recover through the service charges. So I put on that slide limitations of the 93 Act. It's not a wholesale way of just changing the lease completely. There are tactical issues about whether or not it's worth challenging leases. Either side, you or suggested terms that differ from the historic lease, perhaps accepting, but maybe some give and take on the premium. And likewise, one should consider alternative routes to changing the lease terms, such as Part Roman numeral 4 of the 87 Act. And we'll be doing a webinar shortly on the subject of varying leases under the 87 Act and through other means. There are obligatory provisions to go in the new lease. I've put them on the slide there. Now we come over to the issue of conveyancing. There's a process. It doesn't always have to be adhered to, but it's laid down by paragraph 7 of Schedule 2 of the Leasehold Reform (brackets Collective Enfranchisement and Lease Renewal Regulations 1993, otherwise known as the 1993 Regulations. Landlord drafts a lease within 14 of terms of acquisition being agreed or decided by the tribunal, serves that draft lease on the leaseholder. The terms of acquisition are the price, terms of the new lease, but not Section 60 costs. Leaseholders got 14 days to make amendments, otherwise they're deemed to have approved the lease. The landlord's got 14 days to make further amendments, otherwise they in turn are deemed to have approved the lease. And once the lease has been approved, the landlord must send engrossments to the leaseholder. Completion takes place the first working day, 21 days after notice to complete has been served, unless that date falls after the initial 2-month period has ended. Now, the initial 2-month period is the first 2 months after the terms of acquisition have been decided or agreed. What it says in the regs is completion takes place at the office of the landlord solicitor or licensed conveyancer. Following completion, there's also cancellation of any notices protecting Section 42 at the Land Registry or the Land Charges Registry at the request of the competent landlord. So here's an example of the timetable. Terms of acquisition agreed on the 1st of Jan. Landlord serves draft lease by the 14th of Jan. Draft returned by the leaseholder by the 28th of Jan. Landlord approves the draft and any amendments by the 11th of Feb. 14th of Feb, leaseholder is served notice to complete for completion on the 7th of March. However, notice to complete isn't technically valid as the first 2-month period ended on the 1st of March. The landlord and leaseholder therefore agree in writing to complete on the 7th of March, and engrossments are prepared of the leases in preparation for completion. And mortgages are dealt with as well. I've got a couple of slides here which I'll just leave there about discharge of mortgages. It differs on whether the lease was granted on or after the 1st of November. But 1993. But what's important is there's a duty on the leaseholder to send the new lease to the lender if there's mortgage security within 1 month of completion. Now, County Court can get involved again. Following agreement of the terms of the new lease, including the price or determination of them by the tribunal, there's a 2-month period called the appropriate period for the parties to complete. As said earlier, terms of acquisition doesn't include the Section 60 costs. Now, following that initial appropriate period, if no new lease has been entered into, either party may apply to the County Court for a vesting order, compelling completion of the lease, or withdrawal of the notice. And that's to be made within 2 months. So there's 4 months in total from agreement or decision of the terms of acquisition by the tribunal. And the County Court can make such application as they think fit with respect to performance or discharge of obligations arising out of the notice. If application is not made within that period by the leaseholder, it's a deemed withdrawal. I've put on that slide the basic protocol process. It's a Part A claim, written evidence, served on the defendant, and there's indeed 4 months from issuing the claim to serve it. If for tactical reasons one wants to delay service of the claim. Section 60 costs are spelt out on that slide. The leaseholder is liable for any costs incurred by the landlord or any other relevant person, such as other landlords. That's their professional fees, solicitors and valuers, in respect of any investigation reasonably undertaken of the tenant's right to a new lease, any valuation of the tenant's flat obtained for the purpose of fixing the premium, and the grant of a new lease, basically the conveyancing costs. And the costs incurred by any relevant person with respect of professional services rendered by that person shall only be regarded as reasonable if and to the extent that the costs in respect of such services might reasonably expected to have been incurred by him if the circumstances had been such that they were personally liable for all such costs. So the long and short of it under Section 60 is it's not a complete indemnity for the landlord's professional fees. The landlord's reasonable fees, solicitors were relevant valuers, for the heads of work classified under A, B and C. So it could possibly include such work as receiving the counter notice, checking land registry office copies, the valuation itself, and drafting and serving the counter notice, as well as preparation of the draft lease, serving it, amendments, checking them, preparing engrossments, sending out the completion statement, and then proceeding on to completion. The legislation doesn't set out a definitive reasonable amount. If it can't be agreed, the appropriate tribunal has the jurisdiction to decide what should be the Section 60 amount. I suppose whether costs are reasonable depends on how complex the process was. But I mean, if it's worth it, because it's each party pays their own costs at the tribunal, then the leaseholder should ask for a time recording breakdown of the landlord's costs, well, particularly if there's a lot of money involved. The leaseholder ought to consider whether the right grade of solicitor is doing the appropriate work for the landlord, and whether the time spent on each part of the process is reasonable, given the experience of the fee earner doing it. And there's likely to be an economy of scale for multiple lease extension, and that point was reinforced in a case a few months ago, Sinclair Gardens Kensington Investments Limited against Wisby, W-I-S-B-E-Y. So in practice, it may be helpful for the landlord to give the leaseholder a completion statement once the terms of acquisition are agreed, based on the actual costs of receiving and serving the notices, but also on an estimate of conveyancing costs to completion. So back to selling the flat, as a reminder, qualifying leaseholder could serve the notice and transfer the benefit to the buyer, although drafting the notice and serving it, and also the deed of transfer, deed of assignment of the notice could be left to the buyer's solicitor. There should be some agreement reached over the costs, any cost exposure to the landlord, through the Section 42 notice. That's an indemnity for certain costs to the vendor. What I would add is that the deed of assignment, the deed of transfer, the Section 42 notice should be to be effective, to be valid, to work, and not to risk a deemed withdrawal. It should state that the passing of the benefit of the Section 42 the Section 42 notice should be expressed to take place at the same time as the transfer of the legal title, so it should be expressed to take place at the time of registration at the land registry, which is the time, of course, when legal title effectively transfers, not the date of completion. And now any halfway decent precedent for a deed of assignment or deed of transfer of the benefit would provide for that. And finally, situation that pretty common actually, is where there's a missing landlord, missing competent landlord, missing freeholder. My own view is if you've got a situation like this, try and go for a collective enfranchisement through the 93 Act routes available where there's a missing landlord, either a landlord who can't be found or a landlord who can't be identified, because you're still going to have a problem with the missing landlord and lack of enforceability of covenants, even if you get a lease extension with a missing landlord, because the lease is still there. But otherwise, there's a process in place for a lease extension where there's a missing landlord. First one has to check the tenant qualifies for a new lease under the Act. So they're qualifying tenant, long leaseholder, 2 years ownership, registered as such at the land registry. An application is made to the county court for a vesting order, or colloquially called a vesting order, but it's an order to dispense with service of notice of the Section 42 claim. One has to show to get the vesting order from the court that reasonable efforts have been made to find the landlord. Search at the land registry, death certificate search, probate search, adverts in national and local papers, perhaps using the inquiry agent. If the court is satisfied that all attempts have been made to locate the whereabouts of the landlord and that further efforts would not be would be fruitless, then they'll make formal directions, namely that the tribunal is to decide the premium, the appropriate tribunal, and terms of the new lease. The application is then transferred over there. When the premium is decided by the tribunal, it's then paid into the court. Also, draft lease is submitted for approval by the court, and then a district judge or maybe the circuit judge sometimes signs the original lease on behalf of the missing landlord. Money is paid into court, as I said, and I understand goes to a suspect court funds office. Used to be in Kingsway and Holborn, I understand it's gone to Glasgow now. So there's a lot, and the money will remain there for eternity and until such time as the landlord turns up, if at all. And that is the end of this webinar. I hope you found it informative. I've got some questions lined up. I'm happy to take more questions as well, but I see we've got a few questions lined up already. So the first question is, what if you deduce title at the point you serve the initial notice? Do you have to apply again if you get a request to deduce title by the landlord? Well, I suppose the answer is yes. I suppose the answer is yes. You'd have to, because it's a requirement by statute. But I'd be very surprised. They may well not, unless there's been a significant change in, say, office copy entries or the title of its unregistered land. From the date of serving it to the date of deduction, I think that's very surprising. Then I'd be surprised if the landlord picks up Section 60 costs for seeking deduction of title if you served deduction of title at the outset, and I'd be surprised if they got a county court order to enforce deduction of title if you served details of the title at the outset. If the lease is being extended through the Act, is a peppercorn rent a statutory requirement, or can the landlord insist on a higher ground rent? Well, if you do a deal outside the Act, it could be a higher ground rent. But if you complete under the Act, it's going to be a peppercorn rent. And I suspect if you endeavour to register the lease at the land registry, based on the fact that it's a 93 Act extension, and with those 3 compulsory clauses that I touched on earlier, I suspect the requisitions will be raised and perhaps the land registry application will be bounced back. What's the average or typical level of the landlord's costs in such an application? I can't really say. It's always a good idea to have a look at some tribunal decisions on that point, where it's involving the same landlord and the same, perhaps they've got a large portfolio of properties and they've been at the tribunal recently, or maybe the same firm of solicitors. But sometimes I take a very broad view on the Section 60 assessment at the tribunal, based upon the fact that there'll be an expert tribunal with a solicitor usually sitting there, and maybe a valuer as well. Usually these things are done on paper anyway. It's not that common, in my experience, for it to be an oral hearing on a Section 60 assessment of 93 Act costs, but there's usually professionals who might take a broad view of what the costs are likely to be, or they might conduct it more as a detailed assessment. What's interesting, Sinclair Garden against Wisby, I think it was Deputy President Martin Roger heard the case at the upper tribunal, but he had an assessor sitting with him, who's somebody who's like experienced on cost issues. What's interesting about Sinclair Gardens against Wisby is that it was the first case where they've actually said that the solicitor's work for drafting and serving the counter notice could be recovered under Section 60, because it's not explicitly stated in Section 60, and could be done so under any of the three heads, A, B, or C in Section 60. And what is also interesting is that it said that the solicitor's fees for instructing the valuer and for considering the valuer's report were also recoverable under Section 60, although my recollection is that they didn't give them anyway because they were dealt with more. It was just more of an administrative act. And another thing that came out of Sinclair Garden against Wisby is they said that it was legitimate to instruct, in that instance, a grade A fee earner to deal with the conveyancing. It was a well-known landlord using their traditional solicitors, and somebody, I understand it, who'd been pretty experienced in the field of 93 Acts, lease extensions, and the court said, the upper tribunal said that it was reasonable and recoverable Section 60 cost in those instances for a grade A fee earner to be instructed. I think the most interesting thing that came out of that, and which I alluded to earlier from Sinclair Gardens against Wisby, is that they said that there should be a reduction in the cost that they were asking for. I think it was for about 1,000 and something, maybe more, 1,200 and something, to about 800 odd, because it wasn't a one-off. There's a whole bulk of them in the same block that they've been dealt with. So they took the view that the landlord retaining the professional would have negotiated in view of scale, would have negotiated a reduction in the solicitor's fees for dealing with the lease extension claim. Right, any more questions? Somebody's asked, what happens if the freeholder is overseas, outside England and Wales? Well, you could try and serve them outside England and Wales, maybe use a process server, although I think you'd have to give a pretty long deadline for serving a counter notice. You add on to the two months a lot more to take into account, perhaps delays in serving them. But I wouldn't risk it if they're by post if they're overseas, but I'd also check to see that there's a Section 48 address for service of notices, because Section 48 of the Landlord Act 1987 states that if the landlord's based outside England and Wales, they've got to give an address for service of notices in England and Wales. So it's worth seeing if there is such an England and Wales address for service of notice in accordance with Section 48 of the Landlord and Tenant Act 1987. Someone's asked me, can we put an inflated figure for the landlord's counteroffer in the in the counter notice, the Section 45 counter notice? Well, I don't know whether it's good tactics or not. It's not my position to say. What I can tell you is there was a case, I think it was Cornwall Gardens, offhand, it's in Cornwall Gardens in Kensington and Chelsea, which said that there would not be adverse consequences for putting in a high figure in the counter notice. And at that time, I think it was about 10 years ago, that case, Sinclair Gardens, Cornwall Gardens, Royal Borough, Kensington and Chelsea and Sinclair Gardens. But at that time, it had been Cadogan and Morris and Mount Cook and Rosen were the cases about initial notice, and they said that if it was too low a figure, not supported by valuation evidence, then it could potentially invalidate the notice. But the converse was the case with the counter notices, according to the judgment of Royal Borough of Kensington and Chelsea and Cornwall Gardens. More recently, for initial notices, there has been the Dolphin Square case, Friends Life and Westbrook, which I mentioned in the first webinar, whereby it said that it's a genuine opening offer, the figure that's put in the initial notice, Section 42 notice. Right, I'll just wait for some more questions. Somebody's asked me a question. On behalf of my client, I served a Section 42 notice. The other flat owners in the building have now tried to collectively enfranchise. Is there going to be a consequence? Well, the immediate consequence is this. If they serve a Section 13 notice, the Section 42 notice is suspended, it's frozen during the currency of the Section 13 notice. Because the principle is that a collective enfranchisement trumps a statutory lease extension. All right, so I'll wait for some more. What happens when the deposit is returned? Well, the deposit could be returned any time after the 42 Act notice. So the Section 42 notice is given. It could be when it's all completed. So if it falls through, if there's an express withdrawal or a deemed withdrawal. It might be express withdrawal because it might be the tribunal's decision comes up with a figure that they don't like. The thing I'd say is the deposit can then be returned. The leaseholder can give the landlord notice requiring basically insisting on the return deposit, and then it's got to be complied within 14 days. However, the landlord is entitled to deduct their Section 60 costs before handing back the deposit. Now, you might ask, what happens to the interest? Well, it's held as stakeholder, so interest would usually follow who's got the stake. So, if the deposit is returned to the leaseholder, minus the Section 60 costs, then the leaseholder should be entitled to hold on to retain the accrued interest. I've had another question following on from that. Can the landlord simply deduct their costs from the deposit if the costs are in dispute? Well, probably not. I suspect it would all be held in abeyance until such time as it's all sorted out. There isn't anything in the legislation that deals with that point. Something that has to be negotiated, really. What I would say is that the landlord is only obliged to grant the extended lease if, say, it becomes contentious when it applies for a vesting order. If the leaseholder tenders to the landlord both the premium, any amounts that are owing to any intermediate leaseholders and other sums due, such as accrued ground rent, service charges, insurance premiums, etc., and also any Section 60 costs. Now, if any of these are contentious, perhaps they'd be paid into some sort of escrow account, and then in the hope that one can complete from then on, that the monies are there, pending the resolution of any dispute. Right, any more questions? Right, I'll wait a couple more minutes. Thanks. Right, okay, that's thanks very much for the questions, very constructive. Thanks very much. Now I'm going to tell you a little about some forthcoming courses, both a webinar and face-to-face training. The next webinar coming up will be about important case law, the last 6 months or so. Court of Appeal and Upper Tribunal decisions on such matters as service charges, right to manage, collective enfranchisement, lease extension of flats, such as we've been dealing with just now, and individual enfranchisement of houses, you know, the 67 Act stuff. And on the 22nd of November, I shall be doing with one of my colleagues, and we may have a barrister coming along as well, we're arranging that, but we are doing a session on what we call classroom training. It will be at Fleetbank House, where I'm speaking from now, the LEASE headquarters, and it's called Fighting Fit for the Tribunal. That's the first tier tribunal property chamber. Rules, costs and consequences. So it's basically going to be about the procedural rules that came into force in England on the 1st of July 2013. If basically we're going to take you through them, and we're going to review any case law that's arisen that's pertinent. We're going to cover not just the procedural rules, but also orders for costs, because there has been significant recent case law at the upper tribunal on cost orders that can be made under the tribunal procedural rules. And we've also got a spot on preparing for and conducting a case at the tribunal, and it's likely that we'll have an experienced barrister to do that particular spot. So do not feel backwards in coming forwards to book for both the webinar and the classroom training on respectively the 9th of November and the 22nd of November. Well, thank you very much, everybody, for listening to this webinar. In the words of the old 1967 Sergeant Beatles, Sergeant Pepper, Lonely Heart Club Band lyrics, you've been such a lovely audience. We'd like to take you home with us. Fortunately, we can't, but I hope you can join us again in future webinars, and hope we have a chance to meet with you at some classroom training. Have a good afternoon.